Okay, let's get started since it's noon. Thanks everyone for coming to our BulletPoints webinar series. And today we're going to talk about extreme risk protection orders, also known as red flag laws. Also known in California, you'll hear this term as well as gun violence restraining orders. And I'll be presenting a little bit about the history of these laws, as well as some of their applications for clinicians, since our BulletPoints Project really focuses on helping clinicians talk to their patients and intervene in cases that are high risk for gun violence or gun suicide. And then Amanda Abel, who is our top research data analyst with the BulletPoints Project, is going to talk a little bit about some of the research that she's been involved with through the UC Firearm Center, looking at the use and implementation of these laws. So thank you very much for coming. At the end, we will have a Q&A session, and you can put any questions you have for us in the Q&A part of the webinar, and we'll save a little time to go over those. And then I know I can stick around, and maybe Amanda can too, for a few minutes after 12:30, so folks who are able to linger on a little more and might have other questions for us will be there. And otherwise, we'll wrap up at 12:30. And just a reminder that these webinars will happen every third Tuesday of the month, from 12 to 12:30 with a little Q&A session at the end. This is our third one. Our fourth topic is to be determined, but mark your calendars and then look on our Twitter or on our newsletter if you receive that through email. If not, you can sign up to our website to get more information about the topics and how to sign up. So as far as disclosures, our project is funded by the state of California through the UC Firearm Violence Research Center. And we're going to start off our webinar with a brief poll. So thanks for answering these questions. It helps us develop our content and make sure that we're keeping things relevant for our audience. Okay, thanks everyone who answered the poll. And now let's start with some of the webinar content. And just as a reminder, this is going to be a pretty brief overview with a focus on some of the new data that we have from research on this topic. Because we have such a short period of time, but there's of course lots more we can talk about. So I'm going to talk a little bit about how these extreme risk protection order laws, or ERPOs, got their start. And it really began after the Sandy Hook Elementary School shooting in 2012, when a young man went to his old elementary school and killed 26 people, including 20 elementary school children. And of course, this was hugely terrifying to so many people across the nation, and everyone wanted to find a solution to tragedies like this, which seemed to be happening with increasing frequency. But it was unclear exactly what his motivations had been and what might have prevented it. Very soon, the old specter of the role of mental illness in these kinds of shootings raised its head. And quickly, people jumped to a discussion about his mental health history and potential mental health problems, and how perhaps the mental health system should have intervened before a tragedy like this happened. This is a narrative we've seen many other times after mass shootings, is this jump to the assumption that mental illness must have been the cause of this terrible tragedy. And because of that, that the mental health system was the best mechanism for intervention. But the truth of the matter is that it may not be so simple. And that's part of how I got involved in gun violence prevention. Is as a clinical psychiatrist, I understand better than a lot of folks what exactly happens in the mental health system, what we are able to treat, what kinds of disorders we're able to even identify in people who don't present to care, and what the limits of our abilities are. So there are some assumptions about mass shootings that people jump to. One is that even somebody who would do such a terrible thing to innocent school children or strangers in a store or a church must be mentally ill. And then also the corollary that people who have serious mental illness can't own firearms. So of course the mental health system should be able to not only treat this potential for violence out of them, but also prevent them from accessing the weapons that they use to carry it out. And if that fails, but also people who make these kinds of threats to kill other people are committing a crime. And so of course they will be arrested, and the criminal justice system will step in where the mental health system isn't able to. And people who've been arrested also won't be able to buy guns. And that these firearm purchase prohibitions will prevent people who shouldn't have guns from getting them, because of course everybody who has to buy a gun would go through a background check and their name would be on the list and they would be found to be prohibited. So it turns out that none of these assumptions are actually true. And in fact, even in cases where people are prohibited from purchasing firearms legally through the mental health system or the criminal system, they don't necessarily in many states have to go through a background check to purchase a gun. But even before we get to that point, there's a big gap between the mental health system and the criminal justice system in terms of what we're able to do in cases of mass shootings. And oftentimes, people who are making threats to commit these kinds of acts of violence come to my attention because law enforcement has intervened, determined that the information that they have doesn't rise to the level of criminal threats, and that charges and convictions are unlikely. And so they think, well, maybe I can give them some mental health system, and that will be a mechanism to decrease their propensity for violence and also prohibit them from owning firearms. And then when they come into the mental health system, similar problem happens. My hands are tied. I'm not able to do anything. And we're left with this person who really falls through the cracks. So after the Sandy Hook shooting, a group that I work with called the Consortium for Risk-Based Firearm Policy met and pulled together a number of surgeons, ER docs, physicians, public health researchers, attorneys, policymakers, and really talked about what were the points of potential intervention to stop future mass shootings from happening. What was the audience we were trying to target? Because so many of the things that we see when we look backwards and we look at the folks who perpetrate these kinds of shootings, history of playing violent video games, social isolation or awkwardness in the early years, grudge holding at peers or employers. These are very common traits, and it's really hard to pick out who of the people who share those traits would go on to commit an act of mass violence. And so based on the available evidence at the time and the experience of the people in the group, they determined that the best practice was to target high-risk individuals. And one of the things that would make a high-risk individual is somebody making a threat with access to a firearm. And to really take mental health diagnoses and past criminal activity out of the picture in terms of being a requisite. Certainly these things could be taken into account when determining risk, but to not have it hinge on mental health diagnoses or criminal activity, because there are already prohibitions in place there that were clearly not working. People, again, were slipping through these cracks. And while this was all in discussion, another mass shooting and also mass stabbing happened in Isla Vista, California in 2014. This was at a small community in Santa Barbara where a young man who had been posting increasingly disturbing things online and had sent some disturbing communications to his parents had, his parents were concerned enough that they called his therapist in Santa Barbara. And the therapist called the sheriff's department and asked him to go out and do a welfare check because they were concerned he might act on these ideas of his. When the sheriff got to his apartment, they met this young man who seemed very together. He was pleasant and polite. He told them that he wasn't suicidal. He had just had a few rough days and said some things he didn't mean. He didn't appear to have committed any crime. The sheriff's department didn't know this, but in his closet, he had a number of semi-automatic weapons that he had purchased over the course of the last few months, and a large cache of ammunition. Although all of these things had been purchased legally because, like so many of these mass shooters, he didn't have a prohibitory criminal history or mental health history. So he was one of those classic people who fell into this gap where he didn't qualify for a mental health hold. The sheriff considered that and found that he wasn't suicidal, he wasn't making threats to hurt somebody else, and he wasn't having a hard time taking care of himself. He didn't actually even appear to have a mental illness. And he hadn't committed any criminal activity. He was perfectly allowed to own those guns. So extreme risk protection orders are a law that has the potential to fill that gap between the mental health system and the criminal justice system in cases of these kinds of threats. And I was fortunate to be asked to testify for the Senate Public Safety Committee here in California, where we passed one of the first extreme risk protection orders, again known as a gun violence restraining order here, or GVRO. And the other person who was the expert who testified was a sheriff in Santa Barbara County. And a lot of what our testimony was about was how both of us are very limited in what our spheres can do in these kinds of cases, and folks fall through the cracks. We need something to fill that gap, and that's where the gun violence restraining order comes in. Ours was one of the first to be developed, and in California, the gun violence restraining order allows family members or law enforcement, and some other folks too, so employee supervisors, people in the workplace, and some school officials can petition a court to have a person's firearms removed if they're concerned about violence for the near future. And the language that our statute uses is immediate and present danger. It's modeled closely after domestic violence restraining orders, and this was done intentionally, and the name was actually intentional because almost every state has some sort of domestic violence restraining order that can be applied for in a very high risk, hot situation and remove the firearms that can cause that situation to escalate on the spot. So ours is modeled after that. And importantly, it has no mental health evaluation or history required. It doesn't matter why we think this person has a potential for violence, whether they have delusions, whether they have a grudge, whether this is, some other kind of situation where they want to hurt people. We can ask that question later, but the important thing for these kinds of restraining orders is to remove the firearms from the situations as soon as possible. There's three types of gun violence restraining orders in California. And the first is in the blue box. This is the emergency GVRO. Only law enforcement can get these. And this is like if they come to the scene and they find somebody who's waving a gun and making threats, and they need an order right there to take away that gun. They can call a judge on the phone, get the order to remove the firearms, and prohibit that person from buying further weapons or ammunition in the near future. Law enforcement and family members, and also this is true for the school officials and employers, they can petition for an ex parte GVRO. So this is again modeled after domestic violence restraining orders, where the ex parte GVRO involves that person going to court and petitioning, but the respondent doesn't get a chance to be there. It happens in a sort of a semi-urgent situation. But 2 weeks later there's a hearing, and that's when the respondent has a chance to argue their side of the story. The judge at that time can make a decision whether or not to issue an order after hearing. These are the more long-term orders after the judge has heard both sides of the case from both the petitioner and the respondent. And those orders after hearing are much longer lasting. They can be from 1 to 5 years to prohibit that person from owning firearms. Importantly, these are civil orders, not criminal orders, and so they are a different pathway than, for example, removing firearms from somebody for a criminal reason. And now Amanda's going to talk a little bit about her research and what she knows about how these kinds of laws are used in practice.
Great, thank you, Amy. So we've just heard about how ERPOs are designed to work, but let's look at how they're actually used in practice. And I'm gonna rely on Amy to progress the slides for me. So next slide, please. Thanks. So currently 19 states and Washington, D.C. have ERPO type laws in effect. And uptake of these laws has been fairly rapid. All but 2 states have implemented their ERPO laws since 2016, when California enacted its GVRO policy, and several others that you'll see on this map in the light red have introduced ERPO legislation. But research in some of the early adopting states like California and Washington suggests that use of the law has been slow. Next slide. Researchers here at UC Davis collected data on GVROs in California during the first 4 years of implementation. And in that time period, they identified 1,076 individuals who were subject to GVROs, or they're called respondents. Most counties had at least 1 GVRO filed, and although use increased over time, this increase was largely driven by San Diego County, where the city attorney has been a sort of local champion for GVROs. She's publicly endorsed the policy, encouraged its use, and even led trainings throughout the state, training people how to use GVROs. The researchers also found that the vast majority of petitioners were law enforcement officers as opposed to family or household members, and about 1/3 of the orders resulted in the year-long order issued after notice and hearing. The remainder were the emergency or temporary orders that just last for 3 weeks. Next slide. Washington was also one of the first states to pass an ERPO law, which took effect in December of 2016. And researchers there discovered a similar story. Use of the policy varied by county, it generally increased over time, and the majority of petitions were filed by law enforcement. Next. They found that ERPOs were requested in a range of different situations, with 35% of cases involving a threat or risk to both self and harm to others. Next. And the respondents had access to firearms through various mechanisms. So 79% of respondents were said to personally own firearms, but ERPOs were also filed when someone had expressed an intent to obtain firearms, or had used a firearm recklessly, or had access to someone else's firearms. Next. And in 64% of cases filed, at least one firearm was removed from the respondent. Next. In addition to reducing firearm access, another indirect outcome of the ERPO process seen in Washington and as well as in other states is that respondents can become connected to much needed mental health services. So in the Washington study, the court ordered a mental health evaluation in 30% of cases as part of the ERPO process. Next. So we know ERPOs are being used in an attempt to prevent harm, but do they actually work? The short answer is yes. But research on the effectiveness of ERPOs is somewhat limited because it's a new policy and it can take a long time to see reductions in outcomes like suicides and homicides. But research on similar risk warrant laws in Indiana and Connecticut suggests that these laws are effective at preventing suicides. So it's estimated that Indiana's risk warrant law, which was enacted in 2005, was associated with a 7.5% reduction in firearm suicides in the 10 years after its enactment. And Connecticut's law, which passed in 1999, was associated with a small reduction in firearm suicides immediately after its passage, and a nearly 14% reduction from 2007 to 2015, which was after the Virginia Tech shootings, when enforcement of the law increased substantially. Next. So based on these studies, research have estimated that the number needed to treat, or the number of ERPOs needed to be issued in order to save one life, is approximately 10 to 20. Next. There's also some evidence out of California that GVROs have been used to prevent mass shootings. So while reviewing the court records as part of their larger evaluation, our colleagues at UC Davis identified 21 cases between 2016 and 2018 in which GVROs were used in efforts to prevent mass shootings. Among these cases, 52 firearms were removed from 10 respondents, 14 resulted in long-term orders, and by August 2019, when their paper was published, none of the mass shootings had occurred, and no other homicides or suicides by the respondents were identified by the research team. And so we don't know for sure whether violence would have occurred in those cases had GVROs not been issued. So we can't assume a causal relationship, but these studies still illustrate that the tools can be used to prevent serious threats of violence. So if they work, they're effective, then why aren't they used more often? Why has uptake been generally slow in states that have these policies? One major barrier is lack of awareness. So in July of last year, my colleagues and I conducted a survey of California adults and asked if they had ever heard of a GVRO or a red flag law, which is what this policy is known by colloquially. And even though the law has been around since 2016, 2/3 of survey respondents hadn't heard of the law by either name. Next slide. However, after reading a brief description of what the law is, the vast majority said that they would be somewhat or very willing to request a GVRO for a family member in 5 different scenarios, such as if the family member had threatened to hurt themselves, hurt others, or hurt a group of people. So this chart here shows the harm to self scenario. And if you just look at the top bar, you'll see that 59% of all survey respondents said they'd be very willing, and 24% said they would be somewhat willing to petition for a GVRO. And willingness was just as high or even higher among firearm owners and people who live with firearm owners. Next. And this chart here shows willingness when the threat is against someone else, and we see that the results look very similar. So over 80% said that they would be somewhat or very willing to ask for a GVRO, and that included gun owners. Another sign that lack of information might hinder GVRO use is that the most common reason people said that they were not at all willing to ask for a GVRO was because they didn't know enough about them. It was much less common for people to be unwilling because they disagreed with the GVRO concept or process, for example, because they think it's never appropriate to take away someone's guns or they're worried about their due process rights. And lastly, what about clinicians? So what do they think about ERPOs? There's been one study of physicians at Johns Hopkins Hospital in Maryland, which echoes the findings that we've seen in the general population. So Maryland is one of only 2 states and the District of Columbia in which clinicians can petition for ERPOs directly. And in this sample of 92 emergency medicine physicians, pediatricians, and psychiatrists, 72% said that they were not at all familiar with ERPOs. Yet almost all said they encounter patients whom they would consider for an ERPO at least a few times per year, and 60% said they'd be somewhat or very willing to file a petition for a patient who is at risk. The physicians identified time as a main barrier to using ERPOs, such as not having enough time to complete paperwork or attend hearings at the courthouse, and some were also concerned about negatively affecting their relationship with their patient. So I'll turn it over to Amy now to talk more about the clinical scenarios.
Thanks, Amanda, for that overview. And I'm going to talk a little bit about what clinicians' role is with ERPOs. Because as Amanda mentioned, there's only 2 states in which physicians or other mental health clinicians are allowed to be petitioners. But that doesn't mean that these can't be a useful tool for us in preventing not just potential mass shootings or threats of violence, but also suicides, which comprise 2/3 of firearm injuries in this country, and more than half of suicides are by firearms. So as Amanda mentioned, these have been commonly used to intervene when suicide is actually the risk, although they were often developed in response to mass shootings. And the big message is that taking away people's access to lethal means like firearms can reduce both suicide and violence. It's important to note that these laws, ERPOs and GVROs, are for use in high-risk situations, and all of the statutes are going to have some level, like I mentioned, it's an immediate present danger here in California, but they'll have some level of immediacy or urgency that has to be met. And in California or in other states, if the person appears to be potentially violent or suicidal because of a mental health issue and they need mental health treatment, you may want to consider mental health hold. But don't rely on that to be a mechanism for prohibiting them from having access to firearms. You may want to consider a gun violence restraining order or an ERPO to also temporarily remove guns from a situation where firearms could make that situation turn lethal. These 2 things are not mutually exclusive. In fact, they may often be used together. And like Amanda mentioned, in Washington, 30% of respondents were ordered to mental health treatment. There is a mental health component to people who threaten suicide and or violence, but it may not be the surefire way to reduce that threat. And so using these 2 things together may be a way to really cover all the bases. This is a reminder of 5150, and this is California's emergency mental health hold. It does allow for the removal of a gun in somebody's possession when they're detained, but it doesn't prohibit them from, if they get released from the ER or crisis unit, it doesn't prevent them from buying more when they get back or even having that original firearm returned. They wouldn't be prohibited at a California level until they're actually admitted to a psychiatric hospital, which can take a few days, maybe even a week, depending on bed availability, or until they're committed by a judge, at which point they would become prohibited at a federal level and reported to the mixed database as a prohibited person. But again, especially with bed shortages in California, fewer and fewer people are actually getting admitted to hospitals, let alone committed. So for clinicians, and this will be really to wrap up before we start the Q&A, one thing that you can do when you see people who are high risk of harm to self or someone else by firearm is you can talk to family members or law enforcement about potentially filing an ERPO, provide collateral information, and this may even mean testimony. And considering adjunct interventions like mental health holds or even domestic violence or school violence protective orders that may provide additional protections beyond just removing the firearms from the situation. And then, of course, people ask a lot about HIPAA concerns if you were to call a family member or law enforcement and share this information. HIPAA does explicitly say that you're allowed to disclose health information to prevent a serious threat to the health and safety of the patient or someone else to a person who can lessen the threat. And it also expressly refers to the judgment of a health professional. So HIPAA concerns in situations that would rise to the level of a gun violence restraining order shouldn't be a barrier to sharing that information. So that's our quick and dirty overview of gun violence restraining orders and extreme risk protection laws. And you can see more information about this on our website at BulletPointsProject.org. follow us on Twitter and Facebook for more info. And we'll have some time for questions and answers. I know we have one question already in the chat, but if folks have other ones.
Yes, and Amy, I will filter the questions to you. Before we get to Q&A, let's do our closing poll real quick while we still have people here. I think the next slide is for our poll.
Oh.
And then I'll begin asking the questions. Thank you all for participating in that. So one of the questions is about some recent mass shootings that have occurred. The one in San Jose and then also the one in Indianapolis. Can you speak about what happened with ERPOs in those cases? Amy, do you want to comment on that?
Sure, and I'll also say, I know that I'm being echoey and I apologize for that. I'm in a suboptimal recording space. So thanks for bearing with me. Yeah, so we recently had 2 mass shootings where red flag laws were brought up as potential missed opportunities for intervention. The one in Indianapolis was at a FedEx facility where a young man went in and killed some people in his old workplace. About a year prior, he had been evaluated for a mental health hold because he had made threats of suicide by cops. And at the time, they had actually considered placing a red flag order as well. His mental health hold, again, didn't go so far as for him to be admitted or committed to a mental institution by a judge, meaning he didn't meet prohibitory criteria and was able to legally buy firearms once that had resolved. And I can say that as somebody who frequently evaluates people who make threats of suicide by cops, that this is much more often a kind of a crisis reaction situation than a treatable mental illness that would require a hospitalization. So it's understandable to me that he might have been released from that involuntarily highly restricted setting because it may not have been beneficial for his condition at the time. They considered a red flag order, but in Indiana, which had one of the first laws of this kind, the way the law was set up is there were some lessons to be learned from it, one of which is that they had 14 days to respond and gather the evidence for a hearing or the order after hearing. And there's in Indiana, the law also gives you 30 days to respond to subpoenas for medical records. So part of what they needed to support their red flag order was the medical records from his psychiatric evaluation, hospitalization, but they weren't going to be able to get those before the hearing. And they ultimately decided that because of this disconnect, they wouldn't be able to get the order, and they didn't file for it. In San Jose, a man shot up a transit authority where he also had worked and had a grudge against his coworkers or previous employer. And he was the type of person that may have come to the attention somewhat of the authorities for threatening behavior in the past, but it's not clear to me that he ever made enough explicit threats that somebody would have noticed to be a petitioner for the order. You really have to have somebody say things that are concerning enough that family or law enforcement if somebody notices, but that has been the case in a number of school shooting cases and other mass shootings.
Great, thank you. So there's another question about the process of returning someone's guns after the order has expired. Is there an algorithm for evaluating the fitness of the person to return the guns?
There's no algorithm, and to my knowledge, the process is that the order expires and then they can have the firearms back. And this is different than other prohibitions that we have, like some of the federal and state level prohibitions based on certain mental health histories or criminal activity. That there's no sort of exit; it just expires, and it's just, you know, your rights to own a firearm are returned to you. There have been problems in the past with trying to implement a system for restoring some of these firearm rights after they become prohibited, because as you can imagine, very few professionals want to be the one to say, oh yeah, this guy's fine, he won't do anything. We have a very hard time predicting who will be violent and who may become suicidal in the future. And so people don't want to take on that liability, and there's not a reliable algorithm or way to predict it.
Great. And then another question is, could a federal ERPO be passed?
Yeah, and Amanda, do you want to speak to this one?
Yeah, I mean, it is possible that it could be. I think it's a lot more difficult politically, but it has been considered in previous administrations. And I know the current administration has also given a lot of support to ERPOs developing model legislation for states and also considering federal legislation. But up until this point, it's, it hasn't successfully passed, but it is a possibility. So I know we're at 12:30 now. Amy, are there any other, we have a few more questions. Are there any others that you'd like to address in the next minute or so? I want to be respectful of everyone's time.
I will, do you want to, maybe you want to mention the means substitution one, Amanda? That's an important point too.
Sure, yeah. So someone pointed out that suicides have a substitution of means issue. And in the data that we presented, we only talked about firearm suicides, not total suicides, so suicides by other means. And the research has shown some mixed effects on the impact of ERPOs on total suicide rates. And the reason for just focusing on firearm suicide today was mostly lack of time. But yeah, I encourage people to look at the research. There's very limited research. So I don't think we can say definitively yet what the impact is on all suicide rates. But we do know that, firearms are the most lethal method of suicide. And so, if we can prevent people from using firearms for suicide, then we may have more of a chance to intervene to prevent that suicide from occurring. Amy, did you have anything else to add?
No, just I would reiterate that, and that in other studies of looking at lethal means access restrictions, regardless of whether it's firearms or the other most common lethal methods, we don't see a substitution, we just see a decrease in overall suicide rates. And this has been shown in a number of other countries as well.
Great, thanks. Well, thank you all for your comments and questions. Maybe we can chat offline about some of these things because it's definitely an interesting conversation to be had. And just a reminder that this presentation and our other webinars will be posted on our website after the recording is finished. We hope you guys join us in a month for our next webinar series. I think that's it.
Thanks, everybody.
Thank you.